Imagine this. You've poured your heart and soul into your marriage-based green card application. You've waited months, maybe even over a year. And then bam, a dreaded RFE or a NOID, or even worse, a flat-out denial from USCIS. Your dreams of building a life together with your spouse certainly feels shattered. The truth is, many couples face this same heartbreak every single year. Not because they're not genuinely married, but because of common avoidable mistakes in their petition. So, in this video, I will point out 5 of these avoidable mistakes and how to fix them before you get to that place where you get that RFE, that NOID, and of course, the dreaded denial. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards for themselves and their families using the U.S. immigration law system. And yes, I know that system is changing every single day, but these avoidable mistakes will still apply within these changes because these are the things that will trigger all the craziness. So let's make sure you avoid those. So, if you are serious about getting your green card approved, then make sure you stick around and share this video with anyone else that you know are going through the same journey. All right, let's kick things off with mistake number 1. And this is probably one of the biggest ones, not providing enough evidence or strong evidence of your bona fide marriage, meaning you did not bring enough documents for USCIS to look at just the paperwork and say, these people look like they're in a real marriage. They're really building a life together. And if you do not provide that to USCIS, they are going to question your marriage. So you want to start there, okay? USCIS wants to see that your marriage is real, not just for immigration purposes. This is a requirement for filing through marriage, is showing that your marriage is real. USCIS wants to see that your marriage is real and not just for immigration purposes. By the way, that is a requirement for filing for marriage-based green card, in case you didn't know that. They're looking for proof of commingling of finances, a shared life together, and interdependency. Now, how can you show these things? Joint financial accounts. These are great. So joint bank accounts, credit cards in both names, things like that. That's what they're looking for when it comes to joint financial accounts. But before you go and open that joint account, make sure you're both actually going to use it, right? Don't open an account just to have an account. Make sure you're planning on using that account, because if you're not planning on using it, it's useless to you when it comes to USCIS. The next one they're looking for here is shared assets and debts. So for example, joint leases, that means both of you are responsible for paying that rent. If one person skips town, the other person is still on the hook for it. That is shared assets and debts, okay? Mortgage statements showing both of you are responsible for your mortgage. Car titles, car insurance, car lease, whatever it is that show that joint debt, joint asset, you want to show that. Okay, utility bills in both names, not just one name, is also very helpful in these situations. Next thing you can show is proof of cohabitation, because again, this is another requirement, is that you and your spouse are living together unless you have a really good reason for why you're not living together. So cohabitation is really key here. So how do you show cohabitation? Joint utility bills, leases together, letter from your landlord, especially if you have a lease that's like not self-renewing, or that you don't renew your lease every year and it went to month, so you don't have a lease to show. A letter from your landlord does wonders. And then next thing you may want to think about is life insurance or having will, doing your estate planning together. That's also very important if you are going to actually maintain that. Do not get life insurance just to have evidence of your relationship if you are not going to continue paying for that life insurance. I'm sorry, but I have seen this happen where people get it. They're like, oh, someone told me this would be great evidence. And then they never paid it. What's the point? Right? What is the point if you're not actually going to maintain that life insurance? Pictures together. We are not just talking wedding photos, we are talking everyday life photos over time with friends and family. If you take trips together, make sure you're documenting that. Not just with pictures, but with actual like plane tickets, if you flew there, hotel reservations, whatever it is. And when it comes to pictures, make sure you are annotating your pictures, meaning who's in the picture, when was the picture taken, is there a special event that the picture is capturing. Make sure you put that with it, because that again makes a difference. Next good evidence you can add is affidavits. Now, affidavits are low on the list because they are not the strongest evidence of your relationship. Unless you have nothing else, then affidavits are what you can use to show your relationship. I typically will tell you to go with everything else I just mentioned before you do affidavits. Affidavits can come from family and friends that are aware of your relationship, right? They have seen you two together. They know that you two, spend Christmas with them or something. They have to have actual knowledge of your relationship in order to write the affidavit. And that affidavit must be notarized. Okay, so the USCIS has proof that it was actually written and signed by the person that's saying that they wrote and signed it. Please do not make this common mistakes with affidavits. Okay, there's a common mistake people make. They do a template, right? I know this person, they are a great couple. You should approve their case. And they just have all their family and friends get that template notarized. Yeah, USCIS is not going to use that as evidence, okay? Because it doesn't say anything about the relationship. It doesn't say anything about what the person is basing their statement that you two are in a loving relationship on. So don't do that. No templates, okay? Let the person write from their heart how they feel about you two as a couple. And then finally, if you have children together, please make sure that you are including birth certificates, adoption records, whatever it is that shows that you two are the parents of that child. Put that in there. Now, if one of you has a child and that child lives with both of you, make sure you are including evidence of that. So, for example, school records that show that you are listed as the main parent and then the other parent is listed as the step parent on the school records. That's helpful. Medical records showing the same thing. If the step parent is taking the child to their doctor's appointment, that's great evidence of the relationship. Okay? Now, here is an important thing to know. I just listed up a bunch of things that you can include. And some of you may be like, you know what? I'm just going to include pictures. No. Don't just send one or two things from this list. You want to build a strong, comprehensive case. This is something we do for our clients. We look at their whole life and we figure out, okay, what else can we add? What about this? What about that? And by the time we finish, the client's like, oh, I didn't know that would be evidence of the relationship. Yes, it is. Right? Your tax returns is one that I didn't mention under the financial commingling. Your tax returns. Are you filing taxes together? Right? Those are things that you can include. And remember, this is your opportunity to tell USCIS your love story. So I had someone in the past that wanted a review of their packet before they sent it out, which is something we offer in my office. So you fill out your own application, your supporting documents, and then you hire us to do a comprehensive review. And one thing I loved about this particular packet was the way they put together their pictures. Their pictures was basically a timeline of their relationship. And when I tell you, it made so much sense. It made so much sense. I understood their relationship just from their pictures and the timeline that they gave. They basically, the journey from when they met to when they proposed, to when they got married, to when they met each other's families. All of that was in a timeline dated with pictures to back it up. That is telling the story, okay? You don't just want a bunch of documents, you want documents that tell a story. And you don't want to just include pictures, you want to tell stories with your pictures. So remember, you are the storyteller when it comes to your love story to USCIS. Now, if you hire an immigration lawyer, that lawyer will help you tell the story of your relationship. But if you're doing this yourself, make sure you are telling the story of your relationship. Mistake number 2 is a silent killer. Inconsistencies across your forms. USCIS officers are trained to look for red flags. They look for red flags everywhere, from the forms to the documents to the pictures to your tax returns, your whatever you send them. They are trained to look for red flags everywhere. And one of the red flags that you may not even be thinking about is in your documents, is in your forms. So if you say that you moved into your apartment in June on your I-130, but your spouse's I-485 says that you moved in July, that's a red flag. So you're basically telling USCIS that you two have been living together since the day you got married. And at some point within the marriage, you two moved into an apartment at different times. Red flag, right? So if your address history has gaps or your employment history has gaps and the dates do not align, it's going to look like you're trying to hide something or that you just weren't careful, right? Listen, most of the time, it's just you weren't careful. You weren't paying attention to the details. Something was off, but you didn't notice that it was off. That is completely understandable. But these are things that will raise a red flag to USCIS. So how do you avoid it? The first thing you can do is create a master spreadsheet of your life, a timeline of your life. I know it sounds like a lot, but if you haven't moved a lot, you're going to be fine, okay? Remember, when I say a timeline of your life, USCIS, when it comes to the I-130 and the I-485, are looking for your address history for the past 5 years. So you really need to create a timeline of your life for the past 5 years, okay? So it's not that daunting. You can do it. I believe in you, all right? Now, you want to document every job you have had for the past 5 years, every address you have lived in for the past 5 years, because the forms ask for this information, okay? The reason I want you to create this master spreadsheet is that as you are filling out all the forms that are required for your marriage-based green card process, you can basically reference this master spreadsheet every single time it asks you for your address history, every single time it asks you for your employment history. You don't have to go back and remember it because you already did it once. You want to do it once and just copy, okay? Second one, you need to proofread and then do it again, okay? Listen, do you know how many times people have spelled their names wrong on forms and caused issues? Do you know how many times people have put their date of birth wrong? And this is one that people get wrong a lot, and it's not their fault, okay? I can honestly tell you that I have seen people do this, and it is absolutely not their fault, because the US way of writing a date is different from most places in the world, okay? The US does month, day, year. In Nigeria, where I'm from, we typically do day, month, year. And most embassies do day, month, year. But USCIS, because it's in the US, does month, day, year. So if your date of birth is 11/12/2019 and you put 12/11/2019, means completely different things in the US. So you went from being born on November 12th, 2019 to being born on December 11th, 2019. So that is an innocent mistake, but you need to make sure that you do not make it on your forms, okay? So check names, check dates of birth, places of birth, all of that. Make sure you're checking it and it is matching your master spreadsheet, okay? And then finally, if you have ever filed any application with USCIS, with the embassy, you need to make sure that you are consistent through those applications. You need to make sure you have a copy of that DS-160 and you are not putting contradictory information, because guess what? USCIS has access to that and they will use it against you. Mistake number 3 involves the money. Okay, errors on the I-864 Affidavit of Support forms. This is where many petitions hit a brick wall. If the U.S. citizen sponsor doesn't make enough money to meet the federal poverty guidelines, or if you fail to provide the correct tax documents, USCIS will issue you an RFE immediately. Okay, they're not going to wait. When I say immediately, I mean immediately. Because when USCIS cannot see that your sponsor, your petitioner, makes enough money, they are automatically going to stop working on your case. They're not going to work on your work authorization. They're not going to work on your anything. Okay? The only thing they can legally work on is your I-130. They cannot work on the actual green card application and any applications that rely on the green card application. So this is a big deal. All right. So if you're going to get a request for evidence for anything right out the gate, it's most likely going to be this. Now, how do you avoid it? Because it's not just about telling you what not to do, right? How do you actually make sure you avoid it? The first thing you need to do is check your math. Ensure that you have the right household size and that you are looking at the right poverty level for your household size. Okay, people have made this mistake. They think, well, I'm just filing for my spouse. Yes, I have children, but they're not my spouse's children, so we're just a household of 2. No, ma'am, no, sir. Now, when you're thinking about your household size, make sure you're including yourself, your spouse, your children, anyone that you have an active affidavit of support for. So if you have files for someone previously, and they are still green card holders and they do not have 40 quarters with the Social Security Administration, you need to check that, okay? Because they are now included in your household size, whether they live with you or not. The next step, tax transcripts versus tax returns. USCIS is not really picky with the tax transcript versus tax return. Embassy cares way more than they do. But if you are going to put your tax return, make sure you also include your W-2s. This is important because sometimes people don't think about that. Your tax transcript is going to be the most accurate return for you, right? It's going to show everything that you filed with your tax return, all the schedules, everything. Your tax return, if you only send the 1040, which is typically the first 2 pages of your tax return, it's not going to have a bunch of additional information. So you want to make sure that you're also including that W-2 if all you have is your 1040. If you have looked at your household size and your income and you're like, this is not enough, right? You need to look at whether you can get a joint sponsor. A joint sponsor just has to be a U.S. citizen, a permanent resident, and they have to have enough income based on their household size that now will include your spouse that you're sponsoring. And if they have enough income, they can be the sponsor. Okay? So it's really important to know what is required for sponsoring somebody. And knowing that income is so important. Let me know in the comments if you want me to go through the poverty guidelines and household size so that we can basically help you figure out what is your household size and your income requirement. If you have specific household configurations that you want me to look at, put them in the comments and I will probably do a short video just walking you through it. So make sure you're putting your household size or who you believe is in your household in the comments, and I will gladly do some short videos showing you exactly what income level you need to have for that household size. All right. And by the way, if you're getting value out of this video, please hit that like button. Thank you. Mistake number 4 is a technicality that trips up thousands of people, okay? It is not just you. And it is the improperly translated documents or missing long form certificates. Okay, what does this actually mean? If your birth certificate or marriage certificate isn't in English, you need to get it translated into English, okay? And you need to put the translated copy and the original with your application, okay? You can't just send the translation without what it is translated. So make sure you do that. And make sure that there is a certificate of translation. I know. What does that mean? The person, whoever that is doing the translation, needs to certify that they understand English and the language that they're translating, and they are saying that this translation is an accurate translation of the document that you gave them to translate. And then when it comes to birth certificates, USCIS is looking for long form birth certificates. What does this mean? If your birth certificate just has your name on it, does not have your parents' names on it, it's not the right one. Okay, it is not the right one. The easiest way to know what specific birth certificate USCIS wants from you is to look at the Department of State Reciprocity table. I will put a link to that in the description to this video. The Reciprocity table, you go to your country of origin or the country that that certificate came from, and they will tell you what is the acceptable document that they are looking for a birth certificate. So, for example, in Nigeria, you cannot just get any birth certificate, okay? They are looking for one from the national population, right? If you go and get one from your hospital, that's not going to work, okay? If it's not from the right authority, it is not going to be accepted by USCIS. So make sure you're doing that. So, how to avoid all of this? 1, get a full translation. Use a translation service where they can actually certify that their translators know what they're doing. Okay. 2, get the long form of your birth certificate, get the long form of your marriage certificate, make sure you're getting the right documents. The reciprocity table will tell you exactly which document is acceptable for your country. And finally, number 5, lack of disclosure. This is the most dangerous mistake you can make, whether it's a minor arrest from 10 years ago that was dismissed or a previous visa overstay. Do not hide it. I swear, people hide things that does not have an immigration consequence, and it ends up creating an immigration consequence. You heard that right. You refuse to disclose something that does not have an immigration consequence, and that lack of disclosure leads to an immigration consequence. So don't do that to yourself. Do not do that to yourself, okay? It's important to know that USCIS already has your biometrics. They have your fingerprint, they have your picture. They likely know the answer to all the questions before you even submit your form. Hiding information like arrests or previous immigration violations can be considered material misrepresentation, which can lead to you being barred from getting a green card unless you qualify for a waiver that relies on extreme hardship to your spouse. Like, come on, right? Now, how do you avoid that, right? First thing, you need to be brutally honest with your lawyer, right? Okay? If you know that you have anything, criminal history, immigration past issues, anything like that, please consult with an immigration lawyer before you file any application. Especially with this administration, they are looking for any reason to put you in deportation proceedings. So don't give them the chance, okay? It's important to be brutally honest with your attorney because a good immigration attorney will tell you the consequences of those things, whether it actually matters or not. So, for example, if you overstay your visa and you worked without authorization, but you're filing for a green card based on marriage to a U.S. citizen, both of those things are waived by the fact that you're married to a U.S. citizen. Hiding both of those things can lead to a misrepresentation finding that can destroy your chances of getting a green card. So you want to make sure that if you have those things, that you're disclosing it to your lawyer at the beginning so they can figure out the best way to present it to USCIS. If you have criminal records, you want to make sure that you are getting certified copies of your criminal record, okay, from the court. Get that certified copy of the disposition because you need to include it with your filing. But before you include it with your filing, please make sure your lawyer sees it or get a consultation with an immigration lawyer so they can take a look at it and make sure it would not have immigration consequences. Okay? You don't know how many people that have violation of a restraining order. They're like, oh, it's not a criminal case. No, it's fine. It's just a violation. It was later dismissed, or oh, I just had probation. That then end up in deportation proceedings because of that, because they went and filed an application when they shouldn't have. Yeah, I have seen it. So don't do that. If you know you have a criminal history, even if it was dismissed, you want to check with an immigration lawyer first. So a great example of this is if you are in Massachusetts and you had a charge, but it was disposed under quaff, continuous without a finding. So typically, in order for you to get a quaff in Massachusetts as a disposition for your criminal case, which typically means you'll get like some form of probation and then that's it. In order for you to get that, you need to admit to the crime. And it's on the record that you admitted to the crime. So therefore, admitting to the crime means you're guilty of it for immigration purposes. Even though for state, it doesn't matter, right? They just give you your probation, you do your probation, you're done. But for immigration, it does have immigration consequences. So that's why I tell people, even though you think it's dismissed and not a big deal, talk to an immigration lawyer first. I hope those 5 things are helpful to you as you're going through your journey. Remember, applying for a green card is a marathon, not a sprint. And by avoiding these 5 common pitfalls, you are putting yourself ahead of the crowd and significantly lowering your risk of an RFE, a NOID, or a denial. As always, if you found this video helpful, don't forget to hit the like button and subscribe for more immigration deep dives. We're here to help you navigate these systems with confidence. And if you are currently going through your own marriage-based immigration journey, whether you're just starting or you're somewhere still putting together your packet before you file, and you want to get a consultation with me before sending out that packet or before starting the journey, please go ahead and go to my website, lilylegal.com, click on Contact Us, and you can pick a date and time that works best for you for us to talk about your case and get you started on your journey or give you a little push as you're going through that journey. As always, good luck with your journey and please stay safe out there.